Thank you. As was mentioned, David and I are dividing up the topics, and he's going to cover some pending legislation and rule changes that some of the natural resources districts are proposing. And I'll cover some recent Supreme Court decisions and the status of the draft rules for a new fund, the Water Sustainability Fund. I'm required to give a disclaimer at the outset. My presentation is a reflection of my personal opinion. This is not a reflection of the position of the Department of Natural Resources or the Natural Resources Commission. In fact, I'm sure both of those entities would disclaim anything I say. My intent today is to discuss a couple cases and also suggest perhaps how those cases might be applied in some other arenas and in practice and a couple practice cautions as well. First, going to review two cases from the Nebraska Supreme Court and then the recently adopted legislation. The two cases, one is on standing and the other is the Supreme Court's either changing the common law or adding confusion in the use of terminology, which is a real joy for everybody that practices in water law. The first case is the 2007 administration case of the waters of the Niobrara River. Now, this is a case that has a very tortured history. I'll review that history a little bit for you, talk about the decision and some possible implications. This case went to the Nebraska Supreme Court 3 times. The second appeal resulted in an opinion in April of 2012, and that was authored by Judge McCormick. In that case, the use of terminology is really in conflict with prior case law and perhaps the best book on water law that we still have in Nebraska, the Harnsberger and Thorson book on Nebraska water law and administration. In the Harnsberger and Thorson book, they talk about the terminology of how water, the common law was applied in a particular setting. They talked about non-user, they talked about abandonment, and then they also talked about what I think is referred to as statutory forfeiture in the Harnsberger and Thorson book, but a totally different terminology is used by the court. I also want to point out to you a real caution that I would suggest that you need to be very careful about in some of the cases that recently have come down from the Supreme Court as far as things that the court has said. For instance, in this case, the court said that the appropriations priority date is the date that the department approves the appropriator's right to divert, and that's found on page 632. This, of course, is in conflict with state statute, which says that the priority date is the date that a water right is actually applied for and then subsequently granted. Would be a substantial change in our law if the priority date actually were the date that it was granted as opposed to the date of filing. But anybody that read the case would think, without checking the statute, that that was correct. And that's a very big problem if somebody were to actually follow what the court said there. So this case began initially with a complaint filed with the Department of Natural Resources. The appropriators back in 2007 were challenging the department's administration of surface water rights of the Niobrara River. In part, the claim was that their junior rights should not be closed as a result of a call by a senior right downstream. NPPD, the holder of the senior right, had rights for a hydropower plant on the Niobrara River downstream, and they had been making their lease payments. Hydropower is the only type of water right in Nebraska where you have to make a payment to the state for the use of that right. In any event, the request was that they shouldn't be closed for those downstream senior rights. This map shows real briefly the location of some of the places. You can see the Spencer is the downstream hydropower plant, and where the blue circle is an approximate location of the irrigation rights that the upstream appropriators were saying they shouldn't be closed. They held rights on a tributary and also on the river itself. Again, they were junior in time to NPPD's rights. The other significant rights in the basin was for Mirage Flats, and you can see it's far upstream, and for the Ainsworth Irrigation District, which is on the Snake River. In relation to this, the court had said that the common law, as you know, that's the court-made law as opposed to the statutory law. In a 2012 decision, the court said, without examining the legislative history, that the Nebraska legislature in 1993 had not abrogated the common law as it related to how you challenge a water right. In Harnsberger and Thorson, in their book, and in the case of State versus Nielsen, the case cited in my paper, it discusses the common law of non-user and abandonment. And it's fact, this State versus Nielsen case that prompted the legislature in 1993 to change the statutes to say that the only way you can eliminate a water right is through the statutory procedure of 46-229 through 229.05. The legislative history was very clear what the legislature is trying to do, and that was that they're trying to get rid of the common law of abandonment and non-user. In this particular case, the people that were challenging the water right were using the theory of abandonment. So abandonment, as you can see, is the relinquishment of right by the owner without any intent for possession in the future. In this case, NPPD had hydropower facility at Spencer, and they were seeking, they had a priority date of April 16, 2007, with an additional application to get the rest of the water for this particular right. Excuse me. In this particular arena, it's not just the for abandonment. What really is important is the intent of the person that is abandoning the water right. In another area that you might practice, whether outside of water law, abandonment is going to be the question. It's a real factually dependent determination. What is it that you can show from a factual standpoint that demonstrates that the party intended to abandon their water right? The common law of non-user, or as the court in this case called statutory forfeiture, is something different. In that case, you have to demonstrate that for 10 years, the entity was not using their water right. And again, the concept of non-user applies in lots of other areas as well. In real estate law, for instance, it can apply in situations where you're attempting to demonstrate non-user of, say, an easement or something along those lines. In this particular case, moving on to another case, well, let me go back a second. Wanted to just say in this 2014 case, they reviewed the factual findings that the department made in relation to NPPD's uses of its water right and determined that abandonment did not apply, that the facts that were presented at the hearing before the department demonstrated that there had not been any intent by NPPD to ever abandon its water rights. I think one of the concerns that this particular case raises is in the dissent. And the dissent in the decision went through a lot of other facts that had been presented during the prior proceeding. And one of the concerns that this particular case could raise is the question of, is the Supreme Court going to adhere to the standard that factual determinations by an administrative agency, whether it's the Department of Water or Natural Resources or any other state agency, if they're supported in the record, are going to stand on appeal, or are they going to open it up and re-examine and become, in essence, a super administrative agency? I think in this particular case, the dissent really wanted to go back and re-examine the factual basis for the decision and substitute the facts that that particular judge felt were more important. And I think the lesson from this case is that the court has said, no, they're not going to do that. But that is a concern as to how the court in the future is going to look at these cases and other cases. The other case I wanted to look at is one of a series of cases on standing. And I think it raises a real serious question as to how entities can come into court. And I know David's going to talk about a pending bill that raises the question of perhaps broadening the opportunity for entities to get into the courts. This case involved a water right application by NPPD for a hydropower facility, the same one involved in that prior case. In this instance, NPPD had applied for an additional right of 425 CFS for that hydropower facility. This right would bring the total amount of water rights that they have at that facility up to the full capacity of their existing hydropower units. Essentially, this particular facility is a run-of-the-river facility, meaning the water just runs through it. It doesn't store water particularly. It doesn't have a large reservoir. It's just a question of how much flow goes through there. So essentially, they were asking to bring their existing water rights up to the full amount of the capacity of their generation facilities there, as opposed to some people have challenged, if you don't have a water right, then you just have to have the water go over the dam or through the dam without going through the hydropower facility. In this case, the entities that were seeking to become parties included a couple NRDs, the middle and lower Niobrara NRDs, and an individual by the name of Higgins. Mr. Higgins had water rights already in existence, and he also had some applications for additional water rights. In all instances, their applications and the existing water rights that Mr. Higgins had predated those of NPPD. In relation to standing, the allegations from the NRDs were that they didn't have any surface water rights, and they didn't have any applications for surface water rights, and as NRDs, they didn't have any groundwater wells, but they did allege that they did manage groundwater, and that their concern was that in the future, pursuant to Nebraska's Groundwater Management and Protection Act, that if this water right were granted, that it would likely be that Niobrara River under that act would be declared fully appropriated, and that would result in them having to engage in some planning activities. Mr. Higgins alleged that if this water right were granted, it might increase his cost of his pending application. So that's kind of the background. What happened is at the department level, none of those entities were allowed to participate. Instead, it was determined that they didn't have standing. And in the case, the Nebraska Supreme Court upheld that, and they reiterated the standards that they've been using in a number of prior cases, in water cases. And that, as you can see here and in the paper, it says that you have to have a legal or equitable right, title, or interest in the subject matter of the controversy. You have to demonstrate that you've suffered an injury in fact, and it must be concrete in both qualitative and a temporal sense, and that the injury must be to yourself and very distinct and palatable, as opposed to merely an abstract injury. Well, in this case, the subject matter was the surface water of the Niobrara River, not the groundwater. So the court had confirmed that the NRDs had not alleged that they had an interest in the surface water, so their allegations were not upheld. They did not explicitly allege an injury in fact, and the court has said that their allegations in relation to in the future having to engage in some planning activity was conjectural or hypothetical. The Higgins, the court said, did not allege how his costs would have been affected or how his existing rights would have been harmed as well, and so they upheld that dismissal. I think the question that this case and the prior standing cases raised for me is one that's very concerning. You know, Nebraska is a notice pleading case state. We've said that you don't have to allege all the facts, went away from code pleading many years ago, but instead we're now on notice. But that seems to not be the case when it comes to standing. When you look at in the water law arena where this has come up, the Supreme Court in justifying a higher standard when it comes to standing cites back to a number of U.S. Supreme Court cases. Perhaps the one that stands out to me is the Bell Atlantic case. And that case in particular is one that was brought under the Sherman Antitrust Act. And the U.S. Supreme Court was really troubled by those kinds of cases in particular because at the pleading stage, at the very outset, plaintiffs were able to get their cases started, and then they would engage in a very, very expensive pretrial discovery. And the consequence was a lot of those cases, the defendants, in order to save money, would just settle the case because they're so extremely expensive. U.S. Supreme Court was really troubled by that this isn't a proper use of the court system to extract settlement money from defendants just because if you can get in the courthouse door, you can require them to go through a very expensive discovery process. So in that Bell Atlantic case, the court set a higher standard for pleading in relation to standing. I think the difficulty is that's been now applied in other arenas where that wasn't necessarily the concern. In this most recent case, Judge Stephan was one of the dissenters, and he felt as though Higgins should have been allowed to proceed with his complaint. And the rationale that he utilized there, to me, seemed to be a good one. And I'm concerned that if the court continues with the standard that they've utilized, it's going to be somewhat difficult for people to have standing. I want to go briefly, and I don't want to cut into David's time too much, but I want to talk about a couple bills that were adopted in the last session of the legislature because of the significance that they had. In particular, in the waning days of the session, they adopted a couple bills that created the Water Sustainability Fund, which is to be administered by the Natural Resources Commission. Three bills, LB 906, 1098, and 1098A, A means appropriation, is the result of a water funding task force that met and decided, recommended to the legislature that they set up a new way to fund water projects. LB 906 itself is the one that created the Water Sustainability Fund, transferred $21 million into that fund in the last fiscal year. The current fiscal year, another $11 million is to go into that fund. And one of the other things that happened is that the prior funding mechanism for water development projects, the Resource Development Fund, which is also administered by the Natural Resources Commission, is no longer allowed to accept any more applications. A number of other things out of 1098 that was somewhat interesting. It increased the size of the Natural Resources Commission, and I know at least one of the commissioners is here today, from 16 to 27. 14 of those are appointed by the governor, and 13 are elected from NRD caucuses. One of the things that 1098 did is 10% of the funding right off the top goes to sewer separation projects. The only sewer separation projects that would qualify under the definition is the one in Omaha, and as we know, they're facing a fairly substantial challenge in how to fund their sewer separation project. One of the other significant aspects of this bill, and I think it may raise the question of would this be a precursor to other bills like this, or bills with this kind of provisions in it. It required that in the Republican River Basin that the NRDs there and the Department of Natural Resources develop a basin-wide plan that would achieve sustainability of the supplies and uses within 30 years. This is the only basin in which that requirement exists. And it'll be interesting to see how that unfolds, but that was one of the things that was in that bill that came in at the last minute. One of the things that LB 1098A asked was, should there be a cap on this new water sustainability fund? In the Resource Development Fund, they'd had a cap, in part because the Natural Resources Commission had approved projects without any funding available, so that these projects were out there for 6 to 7 years waiting for money. A number of portions of this bill provide directions on how the fund is to be administered. In particular, it now is codified in Nebraska Revised Statute 2, 1506 through 1511. what specifies that applications are to be submitted to the Department of Natural Resources. And then for those applications that are found to be satisfactory, they're then sent over to the Natural Resources Commission. And that commission then is to evaluate those applications based upon 15 criteria that were established in the bill, none of which actually explicitly require water sustainability to be achieved. I think in relation to this, are there other provisions that the legislature might come up with, and David will talk about some of them. One is a cap appropriate. At this point, they've got the $32 million, so that's the limit of what they can approve in the way of projects, recognizing that 10% of that goes to sewer separation projects. One of the interesting things is in the bill it says that the funds are to be distributed equitably across the state, and the question is, how do you achieve equitable distribution if perhaps one project uses all the funds? So I think that's going to be a challenge for the commission as it moves forward, trying to make sure that the funds are distributed equitably. And David will talk about this, and that is there are a number of projects under the Resource Development Fund that did not get fully funded and were kind of left in the lurch as a consequence, and what will be done for them. And I'll let David talk about that. The final thing I just wanted to say, yesterday the Governor's Policy Research Office approved circulating the rough draft of the rules for the Resource Development Fund that the Commission has issued. Public comments will be welcome on that. They are found on the Department of Natural Resources website. The department has to issue a set of rules as well on how the director is to evaluate applications to determine whether they're satisfactory or not, and then to go over to the Commission. Those draft rules are also on the department's website, and public hearings are scheduled for both of those. So if your entity is interested in that particular fund and wants to apply, the rules are out there describing that process, and any comments or suggestions would be welcome. With that, I'll turn it over to David, and thank you very much for your attention.